The Honourable David Cunliffe.
Thank you, Mr Chairman. The clause which we are currently debating is Clause 3, which directs the House to the Principal Act, being the Telecommunications Act 2001. And I think it's important for the House to bear in mind the history of the development of that Act in terms of the shaking of the Chairman's head, which means one might want to stay somewhat closer to the detail of the Act. And so therefore, this is not the occasion to go into the Fletcher inquiry and the review which followed the legislative process, which was a full process, which included a very wide set of consultations, as I recall, with the community. And later led to amendments to that Act around 2005-2006, which followed a 6-month, I think it was called, if I remember rightly, the stocktake review, where every single company was brought in and the nature of the issues confronting the industry were surfaced, and a set of quite far-reaching amendments were brought into play, which broke up the incumbent telco monopoly, which unbundled the local loop, which set in place, I think, a pretty proactive regulatory framework which brought competition to bear in the industry, while at the same time protecting consumer rights and property rights.
I am going to interrupt the member now and to remind him that the House has accepted the principle of the change. Who said that? The member will stand, withdraw and apologise.
I withdraw and apologise. Point of order.
And I'm...
Point of order.
Point of order, Jackie Dean.
Just seeking your clarification, Mr Chair. For what am I withdrawing and apologising?
You're withdrawing and apologising for yelling out while I was on my feet. You were the member who pleaded guilty, I think, to making the noise. Is that right?
Sorry, point of order. Is the Chair asking me a question?
Sorry?
Is the Chair asking me a question?
No, I
thought you were...
Unless, I'll apologise to the member if I've got it wrong, but I thought the member was the member and she did indicate she had. So that's why the member withdrew and apologised.
Yes, I did, Mr Chair. It's just that I was pointing out to the member that it is normal procedure of this House that when the Chair is on his feet, then members sit down. I was merely reminding the member of that fact. So I was trying to be helpful.
And the member will now...
If I'm guilty of anything, I was trying to be helpful.
The member will resume her seat, and I will remind her that when anyone is on their feet from the Chair, members should sit down, but it's the role of the Chair to enforce that and not any other member. And while I might need some coaching, the member is welcome to do that at some stage outside of the House. Right, now, Mr Cunliffe, going back to the point that I was making, this is a very narrow bill. It is the most substantive clause in the bill, but it's a very narrow bill and it does not go back either to the origins of the Act or the 2005 reforms. I think one might be able to go to the amount that we're talking about and that shape of it. The Honourable David Cunliffe.
Thank you for the clarification, Mr Chairman. I guess the point which I was trying to come to, albeit a little slowly, was that the process which this Act or this amendment here is following is so different, sir, from the process which the Principal Act went through on several occasions. Here we are going through a process of urgency without the benefit of a select committee process, and I know, sir, that will be something that you're taking into account in allowing for a full debate of these, albeit quite specific clauses. And so, sir, the reason that is at issue is that a number of members have made the point that there has been no evaluation of the existing $300 million program, which is enshrined in legislation, including its sunset clause. And you, sir, may not have been privy to the statement from the Telecommunications Carriers Forum, which drew attention to the fact that this new tax was overriding provisions made in law around the sunsetting of the previous obligations. That's a serious matter, sir, one which members of certainly this party, if not this side, would wish to see thoroughly investigated by a select committee, which had the benefit of public submissions from the industry as well as consumer groups. So I think I've made the point that I need to make in summary, that this is amending a very substantive piece of legislation. It has fiscal consequences. I think it's now generally accepted by the House. This is a new tax. This is a breach of an undertaking the government did give to the people of New Zealand, that there would be no new taxes. I think it's quite widely accepted around the House now that it is, certainly been stated so on multiple occasions by not only individual companies, but now by the industry group concerned, the Telecommunications Forum. And as such, sir, we're in the situation where we're amending through urgency a very important piece of tax law. Now, Mr Farfur, I think, was earlier going to draw the attention of the House, this will be a matter close to Mr Bennett's heart, that the generic tax policy process has been thwarted on this occasion. As you well know, as members opposite will know, when a piece of legislation which either by amendment to a principal act, as in this case, or if it's a new act which has revenue consequences, goes through, that there is an established convention through the generic tax policy process that the accounting profession and the legal profession be consulted to ensure that there are no unintended fishhooks in the design of the legislation, that there is a sharing process, normally over a period of about 6 to 9 months, where feedback is sought and consultation occurs. And in that way, there are no surprises to the industry, implementation issues are thrashed through, and none of that, sir, none of that is occurring in this case. And I'm sure Mr Bennett will want to rise to his feet and express his condemnation of the Minister for this outrageous breach of standard tax process, one which has kept, I think, the country safe over many years. And, sir, recalling very briefly the impact from the previous clause around the commencement issues, there's no fixed date of commencement.
David Bennett.